Calling our next case of the afternoon, in Ray Davis. Good afternoon, council. This is a 20-minute argument per side. Council, you have the right to reserve time for rebuttal, and you have a free fire zone that you can waive. Please begin when you're ready.
Thank you, Chief Justice and Your Honors. Mark Magyar appearing on behalf of the Michigan Judicial Tenure Commission. The JTC made a decision and recommendation to this court, and what we asked for has partially become moot, and I'd like to acknowledge that and clarify that from the outset. We asked that the court remove Judge Davis and that the court impose a conditional 6-year suspension thereafter. Since that time, the proceedings occurred, the decision was rendered, Judge Davis filed her petition for review, we replied in November, and there was an election. And in fact, the judge wasn't even on the ballot for that election, which we'll get into a little bit. And so as of today, the judge is not a judge, she's a former judge, the respondent. And in 2021, this court decided in the matter of Judge Byron Conchu, and it was determined then to follow the 1981 precedent in the matter of probert, which said you can still do what the JTC is asking you to do, which is impose this suspension on a former judge based on the conduct that occurred while the person was a judge. Now, I'm very familiar with, I worked on that case. My colleague, Judge William Murphy, argued that case. And Justice Kavanaugh, you had your concurring opinion in that case, joined by the Chief Justice Clement. And I think your concurring opinion, I don't want to certainly mischaracterize it, but it's kind of an issue that's been sort of percolating going back to Justice Clement's concurring opinion in Ray Brennan, which Justice Kavanaugh concurred with, and then even back to 2014 in Ray McCree, Justice Michael Kavanaugh had a partial concurring and partial dissent. And the issue that I'm getting at is constitutional authority under Article 6, Section 30 to do this. So the current state of the law, unquestionably under Conchu, is that yes, there is constitutional authority. Yes, the court can do it. And the reason I wanted to front this issue right away, and I'm happy to take any questions, is I think very similar to some of the points Your Honor, Justice Kavanaugh made in the Conchu concurrence, is that we just still don't have that issue teed up for this court. I briefed it in footnote 2, page 4 of the decision and recommendation, saying, hey, look, there was this affidavit of identity, and pursuant to law, the judge can't be on the ballot. So if it happens that by the time we're in front of you, and we made the argument why you can still do it under Conchu, the respondent, for whatever reason, chose not to make that an issue for today. So we have not briefed issues such as the common understanding of what the Constitution meant if it reached to former judges at the time of the Constitution. We have not briefed the issue of, under principles of stare decisis, if it would still be appropriate anyway to adhere to probert, which the JTC would suggest that it is. So frankly, I think in the same way in Conchu that the issue wasn't before the court, it is, again, not before the court. So why am I raising issues that aren't before the court and no one has asked me about? Basically,
I think you've given it more time than anybody has actually so far.
The reason is because it started with having to acknowledge at the very beginning why what we asked for, just like in Conchu, is partially moot. And it's because the judge is no longer a sitting judge, but this court can still impose the suspension that we're asking for, so that if she does then take an election at some point in the future, the suspension would kick in, just as in Conchu. So turning
So
away.
Good morning.
Yes.
Why is that important, though? Like, why not address it at that time?
I think for a couple of reasons. One is we've done the work, and I would pull a passage from Probert, the case dealing with that you can still discipline a former judge, that says if we were to hold that we didn't have power to discipline the judge, or in this scenario, wait until maybe several years later, it would, quote, work undue mischief. Because if a judge leaves and the commission's completed its work and we have all the information and materials necessary to render judgment, then it's the power, this court, to vindicate the integrity of the judiciary by imposing the discipline. And I think really that's a long-winded way of really getting to the heart of what matters, is that's the integrity of the judiciary. When we get into the facts of this case, we're going to talk about a judge who jailed litigants improperly. We're going to talk about a judge who fined litigants. We're going to talk about a judge who illegally parked to the point that a disabled citizen couldn't access their door. We're going to talk about a judge who, if didn't agree with the chief judge's orders, just wouldn't follow them. And when the number one goal in preserving the integrity of the judiciary is what our system is founded on, then you don't sit by and wait to impose discipline only in the event that it becomes necessary. We want to hold that kind of conduct accountable when we see it, I think, Justice Bernstein.
Thank you.
Thanks for that answer, and I don't want to really belabor this, but are you asking, take me back to contracts class, are you asking for imposition of a condition precedent or condition antecedent? In other words, 7 years from today, would this judge be able to file to run for judge? Or are you saying, should this judge ever decide to run, the condition goes into play?
We want the result that happened in Conchu, which I think the best way to answer the court's question is to quote the relief that was imposed there, which is that it's a 6-year conditional suspension without pay, effective on the date of the decision, but should respondent be elected or appointed to judicial office during that time, then respondent will, quote, nevertheless be debarred from exercising the power and prerogatives of the office until at least expiration of the suspension.
Thank you.
Turning to the facts of the case. We briefed this, so I don't want to belabor the point of going over things that are briefed, but I think the petition really spent sort of short shrift on the things that are not in dispute. There were 7 counts of misconduct for a judge who, by all accounts, served maybe a third of the time that a normal judge would have served during that time because of various circumstances. But in that limited time, was able to commit misconduct that was not disputed by the time of arguing on objections to the master's report in 6 of the 7 counts. Now, albeit not every item of misconduct charged in each 6 counts was found or admitted, but there were at least portions of the first 6 counts.
Why did it take the commission so long to complete their investigation in this case?
Well, yes, Your Honor, or excuse me, Justice Viviano. I think first and foremost, the JTC recognizes, especially based on the April 29, 2022 order of this court, that this should have been moved along faster.
Did you need our order to tell you that?
No. I think there were a number of factors going into it. The formal complaint was filed in March of 2020. Within a couple of months, the commission's dealing with 2 motions for a protective order from the respondent to put off answers to the investigation questions, and extensions were granted. There was a complaint for superintendent control during that time period that came up to this court that was ultimately denied in November of 2020. There were 2 amendments to the complaint, including into May of 2022, shortly before the hearing started, just based on the continuing findings of additional misconduct. This complaint started as a 3-count complaint, and by the second amended complaint, it was 7 counts. And of course, I don't want to be one to just sort of blanketly, without evidence, blame COVID, but this is right in the middle of that time period too, and that caused delays in one way or the other for several things. And I think just all of those factors combined did delay this proceeding, and the JTC is very mindful, especially in light of this proceeding, that, keeping it a little tighter is probably in order.
Well, these allegations go back all the way to pretty much when this judge began her term, right?
That's correct, Justice Fabiano.
In 2017.
Yes.
So, yeah, I, for one, was not satisfied with how this was handled. I don't think COVID is a reason to, you wait 3 years to bring the case, then you wait, 3 more years to bring the case to us. So I say all that to say that if the judge was not behaving properly over a long period of time, some of that, the JTC should look inward and think about whether we're sending the message that, you're not watching too carefully.
I think the JT has, and I don't really have any disagreement to make there. I think that's a valid point that the JTC is and has addressed inwardly, internally.
Because we had issues with the judge at some point that, being suspended, and then whether the suspension should be with pay or without pay, and how long that was going to go on for.
You're right, and in your order, you made the correct point, and this is another thing as outside counsel we have addressed, is that the court rule requires a statement of when you think the decision is going to be brought, and that's something that that the JTC is committed to, and especially in light of this case, making sure that's a court rule that they comply with. And I would, obviously you know this, Your Honor, but the ultimate order was a denial in that instance of the without pay, and so the suspensions that occurred throughout, in this case, were at all times with pay.
Counsel, is the requested sanction sufficiently supported by the facts that the respondent admits to, right? There are a number of findings of the master that the respondent admits to, a significant number. Is that sufficient to justify the requested
It's a
relief?
two-part answer. The first direct answer is yes. And we briefed that. The JTC in our both of our briefs said there is so much here. We believe this person is unfit to be a judge. Now, as the court well knows, any analysis on judicial discipline requires the Brown factors, and specifically there's the proportionality analysis. The court typically wants to see what has been done in similar cases. And another case I was involved in besides Conchu was the In re Bruce Morrow case, a pretty recent case. And in that case, we asked for removal. There were no false statements, even at issue. Judge Morrow had made inappropriate sexual comments to some assistant prosecutors, both in the courtroom and in chambers. But it wasn't his first go-around with the disciplinary system. And part of our argument in that case was, if you look to the Brown factors and look to see if this judge has a history, he does have a history, and if you look to see if he's willing to change his behavior, he's not. And at the end of the day, this court agreed with our analysis all the way up to the point of proportionality, saying, we just don't really have a case like this in the past, so we're not going to go with removal. And Justice Czar, you actually dissented, saying you would have gone with the JTC for removal based on the history of disciplinary problems with this judge. And so all of that is to say is, sometimes as a litigator trying to make the argument, you feel a little constrained, even though I fully acknowledge and appreciate why the precedent it is. But at some point, there's going to be new cases. There's going to be cases we've never seen before. Those prior cases had to have come from somewhere the first time they were decided without a prior case just like it having happened. So while I do appreciate the Brown analysis and the need for proportionality, I think there has to be some capacity of this court to look at conduct that has never happened in such a wide-ranging, form as this, where it's, 6 discrete counts of different ways that the judge was misbehaving, and say, this is a proportionate penalty, even if we've not seen this exact case, based on that conduct alone. So that's the long answer to what my initial answer was. Yes, we do believe that even the admitted conduct is enough for the discipline that we've requested. But in this case, and what we said is, we don't really have to grapple with that proportionality question. We think, for the reasons I've just stated, that would support the discipline, but we do have an under oath false statement repeated multiple times in this case. Count 7 of the complaint was numerous alleged misrepresentations. The JTC did not say that those didn't happen, or respondent proved that didn't happen. But the JTC did say, this obviously is a serious allegation that comes with serious penalties, and we're really going to hold disciplinary counsel to, the standard that they have to meet, preponderance of the evidence, and in the end found some of these things, whether the judge had received training when she said she didn't receive training, whether the judge had resided at an address for a certain amount of time, that there was enough gray area to squabble about that we couldn't find by preponderance of evidence those were misrepresentations. But there was one exception where the master didn't find the misrepresentation and the JTC did. And that was with respect to count 4, whether Judge Davis intentionally disabled the courtroom videoing technology and also didn't have a court reporter, thereby rendering those proceedings without any record of any kind, except for in some instances when, in another act of misconduct, the judge recorded those proceedings on her personal cellular phone. And so I'd like to, I see I'm running a little bit short on time. I'll try to save 2 minutes for rebuttal. But
Since you had just gotten to that point of the allegations, can you talk a little bit about the publication, the Facebook publication, and I know the JTC's position is that there was enough to support that allegation, but can you walk through that a little bit, because that's one that I am struggling with.
Sure, thank you, Chief Justice Clement. The master found that, and there wasn't a dispute by the respondent, that she did record these proceedings. So then the disputed question becomes, did she then take the next step of actually publishing them to a platform like Facebook Live? And it's a very short section of the master's report, but essentially the master said the only witness on this issue at all is Shannon Walker, who was the supervisor of the Corporation Council for the City of Detroit. And I'm not convinced that 3 years removed, Walker could remember. And the master actually called Walker credible in this paragraph, but that it'd be really hard to remember something 3 years ago. And I think the issue that the JTC took with that reasoning of the master that sort of put it over the top in the other direction is that if the only witness is Walker, she didn't testify that I'm remembering. She's testifying to an utterance she made presently at the time, which was, Attorney Mullins, now Judge Mullins, I just heard you on Facebook. I'm friends with the judge on Facebook, therefore I can see what she's posting, and you were on there. So the recollection it was a recollection of something that happened in the real time.
So why wasn't Judge Mullins asked that question?
I don't know the answer to that.
And was there any work done to look to see if anything had been published on Facebook?
I'm not aware that was, I do appreciate that was one of the arguments in the petition. My limited, and so I don't want to speak out of school because I'm not a technological whiz, but my limited understanding of things like, and certainly with metadata, and if you want to get into e-discovery, you can find anything, I think, but when it comes to publishing something live, unlike sort of a post that you might put of your child that you can always go back.
It doesn't stay there.
Yeah, it doesn't stay there. And
okay.
that
at least in the easily accessible.
That's right.
But Judge Mullins was questioned.
She was.
But just not to corroborate the questioning that took place with Ms. Walker.
Yeah, my reading of the record is for whatever reason, that scope only made it through with Ms. Walker and not with Judge Mullins.
Thank you.
And, you know, even though maybe I'll run out of rebuttal, that's fine. I do think it's important because of the weight of misrepresentation to try to just address that point is there's no dispute that there was no record being kept, okay? And there's also, so the only dispute is whether, and that was misconduct by itself. And so the only dispute is whether it was intentionally disabled. And the evidence we have for it not being intentional is just the denial of the respondent, which frankly, there's credibility issues there. But then the evidence that it was intentional is a laundry list, and I'm going to try to rattle it off. Please, of course, at any time, as the court should always interrupt me, but the unrebutted testimony that the IT set up, and it was working the day she took the bench there. Very clear in reading the respondent's petition that she came that day upset, you know, consternation about the assignment. It was a demotion to the business license. It was a courtroom far down the hall. Two people, an officer and a clerk, gave testimony that the master found credible. I am out of time, so.
Can I just,
Yeah.
I know you're out of time, can I just circle back to the first statement that you made when discussing this, and you said that, that respondent's credibility was called into question at that point. Can you elaborate on that?
I think it's not conclusive, of course. It is not saying that because there's other misconduct, then you must be lying or you're not telling the truth. But by the time the JTC is reviewing this record, and by the time the master has found 6 counts of misconduct, and the respondent files a brief responding saying, yeah, I don't really take issue with any of that,
Doesn't that bolster credibility? If the respondent is saying, yeah, these things, I would agree to those, and then saying, but I did not do this. I just think we need to be careful when calling into question credibility, given, you know, I mean, it's fact specific, I guess is.
I think it's a fair point that you've just made, Chief Justice Clement. I think parts of it can cut both ways in exactly the way you've said, but also in the way that after a full hearing and you know, you're kind of out of the ability to deny something, then you're willing to say, well, I'll go that far with you, Master. And so,
Okay, thank you.
Thank you.
May it please the court, my name is Michael Schwartz, and I am here representing Kahlilia Davis, who is an attorney and who had been a judge. She's no longer a judge, as we know, because her term is up. I was listening to a lot of the things that Brother Counsel said, and there are a lot of things that are there that wasn't said, that should be said, because then you have a better view of what this is really about. There were problems that occurred, which had they not been, we wouldn't even be here today. Let's say, for example, we're talking about having, excuse me, I'm having problems with my throat, but that's something else. We have situations, people who are court reporters. That's very important for judges because they have to have such persons or some other way to do it so that you could then have a record, and that's very important. It also has an interesting thing. There's a statute, MCL 600.8602, parens 1. And that one says, and I'm going to read it to you because I thought that was interesting. It says, each judge of the district court shall appoint his or her own recorder or reporter. Now, that's a statute, and we're all supposed to follow the law. And if you take a look, and I've got it over here, and you've got a copy of that, I believe. There's a listing of all the court judges in the 36th District Court, 28 judges. Interestingly enough, 2 of them wanted to have video for their purposes. Everybody else, with one exception, was Judge Davis. Everybody else decided they wanted court reporters. It's not that Judge Davis wanted a court reporter not to be used and rather use something else. What happened was she wasn't allowed to do that. In fact, what happened, and this is really what we get into everything that goes on from the former chief judge, Judge Nancy Blount. And what she did is she decided that she wasn't going to give Judge Davis the kind of resources that she should have had. Most important of which is having, among other things, proper training if she's going to end up doing video court. But in addition, she had an obligation to allow Judge Davis to have a court or reporter or recorder. That's what the statute says. If that had happened, all these things that we're looking at would have been done with a couple of exceptions. A few of those exceptions I've put in my brief, and you've read what that says. But when we take a look at what went on, for example, the whole issue about whether or not there was usage of something else. In her case, a court reporter didn't have anything there, so she had to use a cell phone to make a copy of this in some fashion. She had no other way to do it. She didn't have any way to use the video equipment because she didn't know how to use it, and she was never properly
Did she
trained.
ask for help?
Yes, she was told. She never had it. And it's more than that.
When she went into the courtroom and was beginning her work and did not know how to use the equipment, did she stop and say, I need someone here?
It's my understanding that she was aware that she didn't have it. And I believe she talked to somebody. But the key to this is, here she is. She's supposed to have all the resources available to her. And to say, well, and I understand what you're saying, Your Honor, that she should have gone up there and said this. She tried to have a number of opportunities to get court reporters. That was never done. She had her clerk go out and talk to the administrator of the 36th District Court to get that. They refused to do it. What are we supposed to do here? Here's a judge who's just trying to do her job, and she's being prevented from doing that. And it's strange. Out of the 28 judges, she's the only one out of 28 who was prevented from having the resources that all of the rest of them have. And you have to ask yourself, why is that? Because that's not the way these things should happen. We have judges out there, and they're out there for the purpose of doing justice. But you can't do justice if you're not given the kind of resources that are required.
Counsel, a lot of courts have moved to video courtrooms to save money, and I don't know the particulars of why and the timing of why the 36th District Court started doing that when it did. But courts throughout the state are operating on video courtrooms. So
And I
don't-
believe, I'm sorry, Your Honor.
No, so I don't, and I mean, again, I don't know the particulars of the 36th District Court. Judge Blunt, I know it during various times of during her tenure, was dealing with very significant financial problems that the city was having in funding the court, and the court had large deficits. So it wouldn't be surprising to me if it turned out that she was trying to save some money by moving the court, the new judges who came in, to video courtrooms.
But that's not what she said in the testimony that she gave. She said that none of them were required, and it's in I could go through this thing and pick it out for you, that nobody who was having a question as to whether or not they would have to use the video equipment, none of them were required to do that. And in fact, the two judges that came, and Judge Davis came in on 2017, that's when she started. She actually didn't start until March because she had some problems with her health, and she had been in the hospital and had to recover, et cetera. That's not even a question here, because that's agreed by everybody. But when you take a look at all the people who came in, The two new ones that came along with Judge Davis, they didn't want to have the video and they didn't use the video. This was all done not the way you might think it should be done or the way it could be done.
I
That
mean,
didn't happen that way.
Even if, well, I don't know, because I don't know, I haven't gotten into the weeds of the resources of the 36th District Court, but let's assume that they had judges, two of you said that, say there were 3 new judges and 2 took over for judges who had court reporters and 1 did not. And
They
so
came
a
in, they could have
decision-
had,
A
I'm sorry.
decision might have been made to allow 2 of the judges to continue with court reporters and to have 1 judge go on video. That would be an administrative decision of the chief judge, would it not?
No, and the reason is because we still have to get back to MCL 600.8602. And that hasn't been set aside as far as I know. I believe that's still
I have no reason to doubt that, but your client, if she wants to enforce her statutory right, if there is one under that statute, and she has standing to assert it, she has a lawyer, she could have done something about that, could she not?
Oh, I understand that, but it's also there's another provision here that, and I can go in here and get it for you. There's another statute, I'm sorry. Well, I have it here. She has a duty. I'm talking about the chief judge, certain things that they have to do, among which is to assist or provide help to the other judges who may need it.
At a certain point in time, there was a performance improvement plan that went all the way up to the top. It was drafted by the state court administrator himself, was it not?
There was such a thing. I'm aware of that. But at the same time, there were other problems. And let me tell you something else, because this will tell you something that I think is extremely important. We take a look at what happened. We heard from counsel that my client didn't spend a lot of time in court, that she wasn't working. And when you take a look at it, you have a number of situations in which there has been 679 times, not because of my client's medical problems, but because Judge Blount refused to have her in the court or put her in certain types of things, such as, for example, an auxiliary judge, which she had, and that auxiliary judge, she was forced to do that, which, you know,
Well,
it is
wasn't
what
that
it
why
is.
the performance improvement plan was put into place? To help her get back to her
Well-
daily duties as a judge?
Apparently, they said, okay, and put her back. But when they put her back, they then did other things, and I'm not talking about the other people. I'm talking about Judge Blount, because she was the one who was doing all these things. If you look at them, and you look at what she did, she said to Judge Davis, as of March 4th of 2019, up until January of 2020, Judge Blount told Judge Davis that she was no longer required to be at the courthouse and no longer had any duties or responsibilities. Now, that's a whole period of some 9 months. And that's what Judge Blount did. And if that's what you do, that's not something that's probable, it's not good, it's not something that my client just simply had no choice in. Now, she was just told by, and there's an order that they put in there that she was to not appear in the court, and she wasn't.
Well, there was a lot of problems that led up to that. You seem to be overlooking those.
No, I'm looking at all of those, and I have it all in my briefs, and you got them. I don't
Well,
have
what-
the time
so
to do them all, but this
So
is,
your theory is the chief judge just had it out for your client from the
I think-
beginning and would prefer that she not carry her docket load and stay home? That was a preferable state of affairs to the chief
no,
judge?
that's not, my client wanted to be a judge who was in court doing the job that she was supposed to do. That's what she wanted. Now, as far as Judge Blount, there are things that I could kind of surmise, but I can't give you the total thing. The one thing I do know, which is also unusual, she ran for judge, got reelected, and within a couple of months thereafter, she resigned. I don't know why that is either, but it's kind of strange.
Counsel, there's a number of counts, or a number of findings of the master to which you don't object.
Yes.
So let's put aside the ones that you do object to. Why is, you don't object to some of the misconduct that was found by the master? Why are those insufficient to warrant the sanction requested?
Well, the sanction requested is that you go out and say to the judge, you're gone, you're completely removed. I don't believe if you look at all that, that was approved by Judge Stevens. I thought she did a very good job, by the way. She does a good job. She's been a judge for, I don't know, 40 years or whatever. I think she's one of the finer judges that you'll ever find. Excellent. And I looked at what there's there. I looked at what she puts in. There are certain things that she said, no, that's not going to happen, because as a master, she's looking at what goes on during the hearings, and she makes observations.
So the master's finding are to the facts of misconduct, right? And then, given that misconduct that you don't object to, I understand that there is certain misconduct or allegations that you do, but those that you don't, that the master found were supported or corroborated or sufficient, that, you know, the disciplinary council met their burden, then we're looking at the requested sanction, and is it warranted under our case law? Are there cases or a case that you can point to that suggests that of those admitted acts of misconduct, that the sanction requested is not supported by our case law for that?
Well, I think that what I would have to say to you is this. You look at what there is, and there's proportionality, as the other counsel said, and you look at that, and you look at what she's had. She had no prior misconduct at all, either as a judge or as a lawyer. She's never had that. She had certain things that happened which were beyond her ability. On occasion, she didn't know she was coming in early. There were a couple of cases in which she had gone out and utilized contempt proceedings. That wasn't correct. I've admitted that. She now admits it, because she didn't know at the time. That's what she thought was okay. There were a number of other things. But when you look at them all, and you say to yourself, okay, what is it that she's done? What kind of actions did she take that would be what one might say moral turpitude? Because I don't see that there. I take a look at a whole bunch of other things. Now, the master came out and said, well, I took a look at all these things, and she looked at count 7. Count 7 is where the Judicial Tenure Commission come out and says, okay, we're going to find all these things of misrepresentation. In fact, the one person who actually had the ability to look at it and analyze it real well was Judge Stevens. And she found that there was none of them that were appropriate to be found, and she found that they all were not sustained. Now, when you take a look at that, there's nothing else to look at other than these other items that you're making reference to.
Yeah, counsel, I mean, I'm just looking here at my notes. I mean, Judge Stevens found there was misconduct to threaten incarceration as a means to control the courtroom. She found that in the Sanders case, there was an abuse of the contempt power. She found that the JTC met its burden as to the chief judge's requests and not following those. She found that there was a failure to comply with the PIP. She found there was no factual justification. She did find, as to the record, she agreed with you about the video recording. She found there was improper recording. She found misconduct, which we haven't even talked about the use of the handicap placard. So, she found quite a bit of things.
Yes,
so,
Your Honor, I understand that.
So, I mean, those alone you don't think are enough because she was a new judge?
No, I don't think that it's just because she's a new judge, but I also take a look at all those things. She was coming into the judiciary. She didn't have that before she got elected. Yeah, she made a few mistakes. I don't have any problems with that, because that's what happened. But when you look at all that, and then you ask yourself, she's already had 3 years of suspension. Now, my suggestion is that that is appropriate for what should happen. What they're looking to do is way beyond that. They want to go well beyond what that would be. Not only should she be suspended, because she has been, he doesn't mention that at all, but she has been ever since, I think, July 17th of 2020. And now we take a look at what we've got now. We're into 2023. You know, and we're moving up there. There's a lot, you know, that has happened. But to say, well, she should be completely, not only lost her ability to be a judge, but also add on another 6 years on top of all that, that doesn't seem to me to be appropriate. And when you look at what it was, again, there are things, we don't talk about some of these things. My background, in part, is when I used to be the grievance administrator, and I had a good idea of what it's like when you take a look at people and you say to yourselves, okay, is this or is this not reasonable? And then you go on and do what it is. What I've seen over here is a little different. It's a little bit more than being reasonable. It's something like they want to go and do well beyond what is appropriate. And that's something that I think, and it's all up to your honors. You all make the decision. I don't make the decision. He doesn't make the decision. And you're all going to make a decision as to what it should be. But I think what's happened over here, yes, there are some things that she did that were wrong in her, you know, going ahead being a good judge. But where is it that she's engaged? And this is what I'm really interested in, because that's what we used to look at when I was doing the other job. Is there any moral turpitude? Because that's really very important in terms of what you do in terms of sanctions. And you look at what you have, you look at how it turns out, you look at what you have done, whether or not you've done something with intent to do harm or something else. I don't see that in what's been going on here. I don't see where my client intentionally wanted to harm somebody. We don't see that.
Well, intentional harm is not the standard, of course.
I understand that, but it's also something that when you look at a sanction, that's one of the things that you may
Well, what about the idea that she was elected to serve as a judge and couldn't find her way to serve as a judge and handle cases for her, pretty much her entire term of office? So she was a big part of it, she's on paid suspension, but she couldn't find a way to deal with people in the system, the same people that everybody else has to deal with, so that she could do her job. And why should we think that she would be fit to sit as a judge in the future if she were to be elected again?
Well, the reason you know why is because when Judge McConaughey came in for the 6 months that she was there with him, she had no problems
So
whatsoever.
she had a personality conflict with Judge Blunt, and that's sufficient for her to collect her salary for 6 years?
No. What I'm saying is she was doing what she should have done, and she did it properly in that 6-month period once Judge Blount was out. And it's not just to say, oh,
We don't
they
have
had-
anything in the record on that, though, do we? I mean,
Excuse me?
we don't have anything in the record on that, do we?
As to,
About Judge McConaughey coming in and there not being issues.
well, there
I
haven't
mean,
been any.
But that's not on the record. I mean, Judge McConaughey wasn't,
Well, there was no finding anywhere about that. The
I-
Judicial Tenure Commission didn't come out and say, hey, she's doing more stuff there. They just took what they decided they wanted to take. And the only reason I'm saying this is because once she was no longer under the aegis of Judge Blount, the problems that everybody claims are going on now just didn't occur thereafter. And why is
Well,
that?
she was on suspension then, wasn't she?
No, the suspension started in July of 2020. But up until that time, in that period from January 2020 to that period of time, she wasn't under suspension. That's when it started.
thank you, the case will be submitted.
Thank you.